Hello, I'm Derrick. I've been practicing law in South Carolina for 37 years. And in that time, I believe that almost all of my clients have wanted the same four things. They want the real value of their claim. They want to get the real value as fast as possible. They want to be respected and listened to, not treated like a number. And they want a relationship with a lawyer. At the Derrick Law Firm, those four goals guide how we do everything, how we hire, how we work, and how we make decisions. But I believe historically our industry has had a problem meeting those four wants that our clients have. It's not because lawyers don't want to meet those needs, but the playing field that we play on with the insurance industry has not been level. And it's not level because the insurance industry has always had four strong, powerful leverages over our clients and over us, the attorneys. Those leverages are used every day, and they prevent clients from getting the real value of their claim, and they prevent clients from getting paid as fast as possible. I believe that only a very small percentage of injured people receive the real value of their claim in a timely fashion. I know that during the first 30 years I practiced, it was very difficult to get the real value fast. Here's the four leverages that the insurance industry has. Number one, leverage your time. The longer they can make you wait, the more pressure there is to take less than the real value. Number two, the leverage of money. Pursuing a claim to seek real value means court costs and expenses. So you're pushed to accept less than the real value. Leverage three, leverage of uncertainty. Insurance companies claim they have data about what your case is worth, and your lawyer may not have data to counter it. When you ask your attorney, hey, is this a good offer? And the response is, well, you never know what a jury's going to do. It's very easy for the client to fold and take less than the real value. Number four, the stigma of going to court. In past years, the insurance industry did a good job to demonize lawyers, those who brought lawsuits, and juries who awarded large verdicts. There's a large part of society that does not want to be labeled one of those people who sue, because of the tort reform shame that was created during those campaigns. That fear alone can make people settle for less than the real value. Those are strong and powerful leverages. But back in 2014, I stumbled across a way to flip all four. I was doing a focus group on a high-value case. I rented rooms at a convention center. I brought in a videographer. We set up cameras. We brought in 30 people to participate as jurors. We presented both sides of the case. We divided the group of 30 into four juries. They deliberated. We recorded the deliberations. We interviewed all the people afterwards and got just great information. The total day probably cost us $40,000. It wasn't unusual for us to focus group large cases, and attorneys still do that today. But this is the first time I shared the results of those groups with the opposing party as to what these people thought and how they decided the case. And it provided an avenue for my client to receive the real value faster without going to court. That was my eureka moment, when I realized knowing what potential jurors said about a case, how they decided the case, and knowing the reasoning behind their beliefs was a game changer. I needed this for many of my cases. It flipped the leverages, but there was a problem. I can't go out and spend $40,000 to do that on a case that may be worth $150,000. Economically, you can't do that. The only way I could do it was to make this finding of truth a part of our process by doing it inside the offices and eating the cost of the audio and the video, as well as the facilities to hold down the cost to our clients. So we were building an office at the time, and I included a courtroom in it. We have since built 5 additional courtrooms. They are in Myrtle Beach, North Charleston, Florence, Columbia, and Greenville. For cases involving disputed liability, permanent injuries, or reckless conduct, we run a focus group and get the truth from the eyes of the community unless the insurance company offers us all their insurance coverage. Here's the system. We bring in a demographically representative group of people from the county in which the case is pending. We may also bring in virtual jurors where, while we are presenting the case to the 12 jurors in-house, we will present the same case at the same time by Zoom to 50 to 200 people sitting at home. One attorney represents both sides of the case based upon the facts we know, to avoid the jurors making decisions based upon their favorite lawyer. We don't tell them if it's our case or an outside attorney's case. We don't tell them who we represent. We let them know that the results are very often shared with all the parties. We will let them know that what they decide will have an impact on what people do in this case. And we have found they take the job very seriously. After the attorney presents the cases, each person gives us their individual opinion, as if they were a jury of one. We then split the in-house jury into 2 juries of 6 to reach verdicts. After the virtual jurors have finished with their individual decisions, we question them about everything to do with the case and allow them to question us for any additional information they want. We do the same with the in-house jurors when they are finished deliberating. We then use AI to transcribe everything that was said during the evening by the lawyers, the PowerPoint presentations, and the jurors during deliberation and during the squeeze. Our AI system can identify who is saying what. We then put the following into a report generator to create a report about the evening and the results. Number 1, the 107 answers that the focus group jurors gave us when they signed up to serve. These include answers regarding their demographics, their life experiences, and their beliefs about the civil justice system. Number 2, all the jurors' decisions, statements, and verdicts. Number 3, the transcript of the presentation and the arguments made by the attorneys. AI then creates a report that can give us detailed information about the focus group, including verdict outcomes, key observations from the 2 juries, core demographics of jurors, socioeconomics of the jurors, plaintiff summary of the case, defense summary of the case, specific facts presented, key findings from the in-person and virtual participants on all issues with charted visuals, top 10 pieces of evidence that jurors wanted to see but were not presented, the jurors' top 10 pieces of potential unseen evidence that would strengthen the plaintiff's case, the jurors' top 10 pieces of potential unseen evidence that would strengthen the defendant's case, evidence presented by both parties that resonated most with the jurors, 5 psychological studies and principles affecting jurors' decision-making, including cognitive biases, group dynamics, emotional and moral dimensions, persuasion and storytelling principles, and social and demographic influences. Individual juror assessment, analysis of strategy for both parties, assessment of settlement ranges, key leverage points for negotiations, risk assessment for proceeding to trial, attorney performance ratings, and anything else that we want to capture from what was done and said at the focus group. How do we use what the focus group tells us? There are 4 main ways that we leverage the focus group results. Number 1, build a case like the jury wants to see it and hear it. They tell us if there's additional evidence that they would like to see if they were on the real jury. The first leverage is to our attorneys in building cases. If they say we need additional evidence, and that evidence exists, we need to go get it, bring it back, and present the case again to get the real value of the case. Number 2, inform the client. If the focus group indicates they have all the evidence that they want, and they give us the chance of winning and the range that is the most likely outcome, we inform our client so that he or she can decide as to how to go forward. Do we try to settle? What do we settle for? Or do we go to trial? Number 3, leverage the truth that we obtained with the defense and the insurance company on the other side. Show them what the outcome is going to be. Show them the chance of winning. Show them the strengths and weaknesses of the case so that everyone knows the real value of the case. We very often share all the results, including the presentations, the deliberations of the jury, with the insurance company. Remember, our clients want the real value of the case, and they want it as fast as possible. In South Carolina, we have a law that says that insurance companies are to act reasonably, and if they don't, they're acting in bad faith and can be liable for bad faith insurance practices. For the first 30 years of my practice, insurance companies would tell me they are not acting in bad faith. They just disagree with me regarding what 12 people will do with the facts of this case. We have now taken away that argument. We show them what 12 people or 112 people would do. So we're using the leverage of truth and the law of South Carolina to make insurance companies pay our clients faster. The fourth way we leverage it is to build a data-driven case presentation if the case goes to court. We know from our data what's important to jurors to guide them in deciding cases the way they do. We can take that data, that information regarding jurors who share demographics, life experiences, and beliefs, and we can fine-tune our facts, presentation model, and arguments at trial to each of those people based upon how similar people have responded in our focus groups. Well, those are the 4 main ways that we leverage an individual focus group. The great multiplier of leverage is that we've kept the data from all our focus groups we've done. So we have a database with over 10,000 people's opinions about cases. Those 10,000 people have given us 107 data points about themselves. When we started accumulating all these focus groups, we put it into a machine learning system through Domo that built us a dashboard where we can not only look at a single focus group, but also look at the big data behind it. If this one case involves a certain issue, we can look at all focus groups that involve the same issue. This big data behind the individual case can increase leverage because the data set is larger. It's not what 12 jurors decided, but also 200 people from other similar cases. In Domo, as you can see on the screen, we can pull up average values. We can pull up the top third versus the bottom third of jurors and how values change based upon if we can eliminate the bottom third of jurors during jury selection. It also gives us a way to identify who we should strike. If we put in a case type, we can go back and look through all our data and see the answers to the 107 questions that made a difference in someone being a very good juror for us or a very bad juror for us in that particular type of case. It may be what kind of work they do, the political party, their age, or other demographics. It may be a life experience, if they took care of an injured person, if they have a similar injury, or if they caused an accident in the past. It may be a belief in the civil justice system, about our laws, whether someone should get money in a wrongful death case, or their opinions as to whether there's too many lawsuits. Our data will tell us which of those questions drove someone to be a good juror versus a bad juror. We can see it in the regression table. And what that shows us is there is a statistical significance to that answer. If they answer the question this way, they are 2, 3, or 4 times more likely to be a bad juror than a good juror. And we can look at which data points made the biggest difference, so we can find the answers to those questions on potential jurors before they show up to the courtroom. With that information, we can play the odds and increase our chances of getting a good jury. If I was in a state where I could do voir dire, where I could question the potential jurors before they are seated, I would know exactly the questions to ask to identify those who have proven in similar cases to be bad jurors for this case. The most exciting thing we're doing at this time is we're moving from the machine learning domo to an AI warehouse where all our data is confidential and safe, where we can talk to our data the same way ChatGPT talks to the internet. And we're in the process of building an AI system trained on our data that will allow us to put in specific case facts, and it will tell us how to build that case for the jury, what the jurors have told us they wanted to hear, and a grading system for potential jurors at real court that identifies the jurors that we should strike. Finally, it will also provide predictive analytics regarding the chance of winning and the anticipated verdict and value from the 12 people who end up on the jury. We will use our data to be able to tell our client our chance of winning and the estimated range of verdict from the data and the data alone before we give an opening statement. We can never guarantee an outcome. We can never guarantee an exact amount, but we are playing odds, and we're trying to increase our odds of getting good results, the real value at every step of the way. Finally, we'll be able to use this AI system to take the 12 people in the box, run them through our system to tell us what each of those people will respond to in the form of facts, presentation models, and arguments, so that we can individualize our argument during our case in front of each of those 12 people. Changing from machine learning to AI is allowing us to not only capture information from structured data, but also from unstructured data, and to do it faster. We are on pace to have the first working model in January of 2026, at which time we will test all of it. We will test all the predictive analytics regarding what juries want to see, how they value cases, and what presentation models work for them, and who makes good jurors and bad jurors every time we do a new focus group. What does this all mean to you? It means you won't hear, "I don't know," you never know what a jury is going to do. At the Derrick Law Firm, we'll give you information to choose what you want to do in deciding when and if you're going to settle or go to trial. We're going to continue to improve our data moving forward. We're not going to use hunches for anything we're doing. We're going to use data. We're going to use data to build a strong case, determine the validity and value of claims, pick a jury based upon thousands of focus group participants, show you what the data says about the 12 people who are left on the jury, and then make an individualized presentation at trial if the case goes to trial. We are not going to base our suggestions and opinions on what insurance companies want to voluntarily pay people. And we're not going to sit back and let insurance companies apply their leverages on you to make you take less than the real value. We will continue to do everything possible to flip those leverages and try to get you the real value as fast as possible. When I look back at 2018 before we started doing focus groups, through the end of 2024, our average case value over that period has risen 150%. because knowing what we know now gives us the leverage to get better outcomes for our clients. That means that the average settlement value in 2018 was only 40% of the average settlement value in 2024. I believe that change through this system is what has driven our growth from 5 lawyers to 32 lawyers, from 1 office to 10 offices, and has resulted in over 6,000 5-star reviews as of November 2025. If you need an attorney and would like a firm that will work with you and do everything they can to get you the real value of your claim faster, while giving you 5-star customer service, give us a call.